I'm Catherine Sullivan, family court judge for 20 years. Yesterday, my daughter-in-law Vanessa confronted me outside the courthouse, her eyes blazing with entitlement. "I know you're meddling in my custody case," she hissed, pointing her manicured finger at my face. Before I could respond, her hand connected with my cheek in a stinging slap. The court security officers froze in shock. Vanessa smirked, thinking she'd put me in my place. Then I removed my sunglasses, revealing my judicial robe. Her smug expression crumbled as she realized whose courtroom would be deciding her custody case today. Before I share how this shocking confrontation unfolded, drop a comment telling me where you're watching from. Hit that like button if you've ever had to deal with difficult in-laws, and subscribe to hear more stories about family drama and justice being served. Now, let me take you back to how my relationship with Vanessa deteriorated to the point of physical assault in front of a courthouse. My legal career spans over 30 years, with the last 20 dedicated to family court. I've built a reputation as fair but firm someone who always puts children's well-being first in custody decisions. My colleagues respect my commitment to ethics, and lawyers know I cannot be swayed by emotional manipulation or theatrical courtroom displays. Family court is challenging. We see people at their worst, fighting over what they love most. I've always prided myself on remaining compassionate while applying the law equitably. My personal life has been more straightforward than many of the cases I oversee. I was widowed 12 years ago when my husband, Robert, died of a heart attack. He was my rock, a brilliant criminal defense attorney who understood the emotional toll my work took. Our only son, Michael, followed us into medicine rather than law, becoming a dedicated pediatrician who specializes in developmental disorders. Michael was my pride and joy, studious, compassionate, and driven. After losing his father in medical school, he threw himself into his studies, graduating with honors and securing a prestigious residency. He worked long hours but found fulfillment in helping children. By 30, he had established a successful practice with 2 partners, treating many low-income families pro bono. His only regret, he once told me, was not having found someone to start a family with. That changed 4 years ago when he met Vanessa at a hospital fundraiser. She was stunning, articulate, and seemed genuinely interested in his work. As a marketing executive for a pharmaceutical company, she moved in similar professional circles. Their courtship was whirlwind. Within 6 months they were engaged, and married 3 months after that. Initially, Vanessa charmed everyone, including me. She organized elaborate dinner parties, remembered birthdays with thoughtful gifts, and seemed to make Michael happier than I'd seen him since before his father died. But small warning signs appeared. She would call him repeatedly during our mother-son lunches. She questioned his friendship with a female colleague in ways that seemed possessive. She made subtle criticisms of his modest lifestyle, pushing for a larger house and luxury car. After the wedding, these behaviors intensified. Michael's weekly calls to me became monthly, then sporadic. When we did speak, he seemed guarded. Twice, I heard Vanessa in the background asking who he was talking to and why it was taking so long. When they visited for holidays, she dominated conversations and frequently contradicted Michael's opinions, sometimes with a sharp edge that made everyone uncomfortable. The real change came with the birth of my granddaughter, Emma. The pregnancy seemed to bring out both the best and worst in Vanessa. She glowed with maternal pride, but became intensely controlling. She restricted visitors after the birth, claiming concerns about germs ironic given Michael's medical expertise. I was allowed only brief, supervised visits. Despite these limitations, I formed a special bond with Emma. She had Michael's curious eyes and gentle temperament. By her 3rd birthday, she would light up when I visited, running to show me her latest drawings or books. These moments clearly irritated Vanessa, who would often interrupt or suddenly remember Emma needed a nap. 6 months ago, Michael called me late one night, his voice breaking. He and Vanessa were separating. He wouldn't share all the details but mentioned emotional manipulation, controlling behavior, and discovering Vanessa had been secretly recording their arguments and editing them to make him appear unstable. "She's threatening to take Emma away, Mom," he said, the fear evident in his voice. "She says with my work schedule, no judge would give me custody. She doesn't care that I've rearranged my entire practice to be home every evening and weekend." When he mentioned they'd be going to court, I immediately explained I would need to recuse myself from any proceedings. The family court in our county isn't large, 5 judges handling all domestic cases, but I assured him another judge would be assigned. I even contacted the chief judge preemptively to ensure there would be no appearance of impropriety. This transparent approach backfired spectacularly with Vanessa. She somehow interpreted my recusal as evidence I was secretly working against her, telling mutual friends I was pulling strings behind the scenes to help Michael. Nothing could be further from the truth. I had meticulously avoided discussing the case with any of my colleagues. The first real betrayal came at a community fundraiser 2 months ago. A lawyer I've known for years approached me, looking uncomfortable. "Catherine, I thought you should know. Vanessa's been telling people you've been discussing Michael's case with other judges, trying to bias them against her." I was stunned. Such behavior would be a serious ethical violation that could end my career. Vanessa hadn't just attacked me personally. She'd struck at my professional integrity, the cornerstone of everything I'd built over 20 years on the bench. What made it more painful was knowing that these rumors could potentially taint the proceedings, hurting Michael's chances for fair consideration. That night, I sat alone in my study, surrounded by law books and case files, wondering how the woman who had once brought such joy to my son's life had become so determined to destroy not only their family but my reputation as well. Little did I know then that this was only the beginning of Vanessa's campaign against me, and that her most shocking act was yet to come. The formal custody proceedings began with Michael filing for primary physical custody of Emma. His petition cited Vanessa's increasingly erratic behavior, instances of her leaving Emma with various friends without notice, and concerning incidents where Emma returned from time with Vanessa showing signs of emotional distress. As a pediatrician, Michael documented these changes meticulously. Emma's new nightmares, regression in toilet training, and sudden fear of making mommy angry. Vanessa's counterpetition arrived a week later, painting a completely different picture. She portrayed Michael as a workaholic who played dad when convenient but left the real parenting to her. She claimed his medical practice always came before family, and that Emma cried when she had to go to boring daddy's house where there was no fun. The allegations were demonstrably false to anyone who knew Michael, who had actually reduced his patient load by 30% to accommodate more parenting time. Though I maintained my professional distance, privately I struggled. I'd witnessed firsthand Michael's dedication as a father, reading the same princess story 20 times in a row, building elaborate blanket forts, and sitting patiently through Emma's earliest attempts to cook in her play kitchen. I'd also seen Vanessa check out mentally during these activities, absorbed in her phone while Michael engaged with their daughter. The court assignment process in our county is normally straightforward. Cases are assigned randomly among available judges based on caseload and scheduling. Given my recusal request, Michael and Vanessa's case should have automatically gone to one of my 4 colleagues. I was horrified when my judicial assistant, Barbara, entered my chambers one morning looking concerned. "Judge Sullivan, there's been an administrative error. The Sullivan-Carson custody case was initially assigned to your docket. Carson was Vanessa's maiden name, which she had readopted after the separation." My blood ran cold. "How did this happen?" "The new clerk didn't flag the surname connection," Barbara explained. "I caught it during morning review and have already requested reassignment." "Who's available?" I asked, already drafting the formal recusal in my mind. "Judge Carlton has the lightest docket this month." I nodded, relieved. William Carlton was a fair-minded jurist with 25 years of family court experience. Process the reassignment immediately and make sure all parties are notified of the error and correction. Within an hour, the paperwork was filed and the case was officially transferred to Judge Carlton's docket. I thought the matter was resolved until my phone rang that evening. "How dare you manipulate the system this way?" Vanessa's voice was cold and accusatory. "Excuse me? Don't play innocent. You had the case assigned to Carlton because he's your golfing buddy. Everyone knows you two are thick as thieves." The accusation was so absurd, I almost laughed. William Carlton and I have never played golf together. The case was randomly assigned, and I recused myself, as is ethically required. "Save it," she snapped. "Michael told me you've been pulling strings from the beginning." This stunned me. "That's absolutely false. Michael knows I've had no involvement." "We'll see about that. I have friends too, Catherine. If you want to play dirty, I can expose just how your precious courtroom really works." The threat hung between us. Vanessa, making false accusations against a judge is serious. I strongly suggest you speak with your attorney before pursuing this course. Or what? You'll make sure I never see Emma again. That's been your plan all along, hasn't it? That's enough, I said firmly. This conversation is inappropriate. Any concerns about judicial assignment should be addressed through proper legal channels. Goodbye, Vanessa. As I hung up, my hands were shaking. Not from fear, but from the effort of maintaining my composure. In 20 years on the bench, I'd been called many things by disgruntled litigants, but never had someone so personally connected to me accused me of judicial misconduct. The second betrayal came just days later, when I received formal notice that an ethics complaint had been filed against me with the Judicial Conduct Board. Vanessa alleged that I had improperly influenced the case assignment and had been having ex-parte communications with Judge Carlton about the case. The allegations were easily disproven. The court's assignment system is automated and logged, and Judge Carlton and I had not communicated about any active cases. But the damage was done. An investigation would be conducted. My colleagues would know of the allegations, and regardless of the eventual finding, a shadow had been cast. What hurt most was the realization that Vanessa truly believed I would compromise my judicial integrity, or perhaps she didn't believe it at all, but was willing to make the accusation purely as a tactical maneuver. Either possibility reflected a distressing view of justice as something to be manipulated rather than upheld. As the preliminary custody hearing approached, I threw myself into my own caseload, meticulously avoiding any mention of Michael and Vanessa's dispute. I advised Michael to communicate with me only about Emma directly, not about any aspect of the legal proceedings. "Mom, I'm so sorry about all this," he said during one of his now rare visits with Emma. "I never thought Vanessa would target you this way. It's not your fault," I assured him, watching Emma arrange stuffed animals in a careful line on my living room floor. "The system will work as it should." His expression was doubtful. "She's convinced herself you're her enemy. I've tried to explain the reality of judicial ethics, but she won't listen. She sees conspiracies everywhere now." Looking at my granddaughter, innocent and unaware of the adult conflict swirling around her, I felt a renewed commitment to maintaining the ethical boundaries that would ultimately protect her. Whatever personal cost I might bear, the integrity of the process that would determine Emma's future was paramount. I couldn't have imagined then just how high that personal cost would climb, or that Vanessa's next action would cross a line from unethical to illegal in full view of the courthouse where I had served justice for 2 decades. The ethics investigation proceeded with excruciating thoroughness. Investigators interviewed court staff, reviewed assignment logs, and examined my communications. Though I knew I would be cleared, the process itself was humiliating. Colleagues avoided eye contact in hallways. The court administrator, normally friendly, became formal and distant. A reporter from the local paper called asking for comment on allegations of judicial misconduct, forcing the court's public information officer to issue a statement about the ongoing investigation. Throughout this ordeal, I maintained my usual caseload and demeanor on the bench. Litigants deserved a judge focused on their issues, not distracted by personal problems. But the stress took its toll. I lost weight, developed insomnia, and found myself jumping whenever my phone rang, wondering what new accusation might be coming. Meanwhile, Vanessa escalated her campaign beyond the official complaint. At a hospital benefit, I overheard 2 colleagues' wives discussing how that Judge Sullivan had supposedly tried to sabotage her daughter-in-law's custody case. At church, longtime members suddenly found excuses to sit in different pews. My neighbor, whose daughter attended the same preschool as Emma, awkwardly mentioned that Vanessa has been saying some concerning things at drop-off. The isolation would have been unbearable without my close friend Susan, a retired prosecutor who knew me well enough to dismiss the rumors outright. "Catherine, anyone who believes you'd compromise your ethics doesn't deserve your concern," she insisted over coffee. "This will pass, and the truth will prevail." Michael was devastated when he learned of the ethics complaint. "I never thought she'd go this far," he said, his voice hollow with disbelief. "I've told my attorney to make it clear in writing that I have no concerns about judicial impropriety. That's appreciated, but unnecessary," I assured him. "The investigation will show there was no misconduct." His expression darkened. "You don't understand how Vanessa operates. Once she has a narrative in her head, she finds ways to make everything fit it. If the ethics board clears you, she'll just claim they're part of the conspiracy too. I wanted to dismiss this as exaggeration, but Michael's assessment of his estranged wife had proven accurate so far. What worried me most was the effect of the conflict on Emma. Michael reported that she had become withdrawn and anxious, particularly around transitions between households. She asked me yesterday if Mommy and Daddy hate each other, he said, eyes glistening. How do you answer that? The preliminary custody hearing was scheduled for a Tuesday in early October. By coincidence, I was due at the courthouse that same morning for a different matter, finalizing an adoption that had been 3 years in the making. It was the type of joyful proceeding that reminded me why I had chosen family court, a welcome counterbalance to the contentious divorces and custody disputes. After concluding the adoption, around 10:30 a.m., I headed toward the side exit, planning to leave before Michael and Vanessa's 11 a.m. hearing. I wanted no appearance of being present for their proceedings. The exit required passing through the main corridor, which was busy with the usual mix of attorneys, litigants, and court personnel. I spotted Vanessa immediately. She stood near the water fountain, engrossed in conversation with her attorney, a sharply dressed man I recognized as Thomas Reed. Known for his aggressive litigation style, I kept my head down and walked briskly, hoping to pass unnoticed. Well, look who it is. Vanessa's voice cut through the corridor noise. The supposedly impartial Judge Sullivan. I should have kept walking. That would have been the prudent choice. But something, perhaps fatigue from weeks of whispered accusations, perhaps concern for my son and granddaughter, made me stop and turn. Vanessa, this isn't appropriate. Your hearing is about to begin, and I have no involvement in it. She stepped closer, her designer heels clicking on the marble floor. No involvement? That's rich. Everyone knows you've been coaching Michael on what to say. Her attorney placed a restraining hand on her arm. Miss Carson, I advise against this conversation. She shrugged him off. No. I'm tired of the pretense. She thinks because she wears that robe, she's above it all. But she's been working against me from day one. The corridor had grown quieter, people sensing conflict and slowing to watch. Court Security Officer Wilson had noticed too, moving casually closer to our position. These accusations are false, I said quietly, and this is neither the time nor place. Of course, it's not convenient for you, Vanessa interrupted, her voice rising. It never is when someone calls out the corruption. You've poisoned Emma against me, haven't you? Telling her what a terrible mother I am when she visits your precious house. The accusation was so outrageous I momentarily lost words. Emma and I baked cookies and read stories during her visits. We never discussed her parents' conflict. That's absolutely untrue, I finally managed. I would never involve Emma in adult matters. Liar. Vanessa's face contorted with rage. You've been working to take my daughter away since the day she was born. You never thought I was good enough for your precious Michael. Several bystanders gasped at her volume and accusations. Officer Wilson was now only a few feet away, clearly concerned about the escalation. Vanessa, please lower your voice and speak with your attorney. This outburst can only hurt your case. Perhaps it was my calm tone, or the mention of her case, but something in my response pushed Vanessa over the edge. Don't you dare tell me what will hurt my case. Her hand moved so quickly I had no time to react. The slap connected with my left cheek, the sound echoing in the suddenly silent corridor. My glasses clattered to the floor. For a moment, everyone, security, attorneys, courthouse staff, froze in shock. Vanessa's expression shifted from rage to smug satisfaction. She clearly believed she had publicly humiliated me. Put me in my place. The smirk that spread across her face revealed something I had never fully appreciated before. She genuinely saw herself as the wronged party, justified in any action she took. Officer Wilson snapped into action, stepping between us. Ma'am, put your hands behind your back. Only then did reality seem to dawn on Vanessa. What? You can't be serious. You just assaulted someone in a courthouse, Wilson stated flatly. That's a criminal offense and contempt of court. But she provoked me. Vanessa looked around wildly, seeking support from the stunned onlookers. As Wilson recited Miranda rights and secured handcuffs around Vanessa's wrists, another officer retrieved my glasses. The left temple was bent, and I could feel a stinging sensation where her ring had caught my cheek. "Judge Sullivan, are you all right?" the officer asked. "Do you need medical attention?" "No, I'm fine," I assured him, though my hand trembled slightly as I took the damaged glasses. Thomas Reed approached, looking mortified. "Judge Sullivan, I deeply apologize. I had no idea my client would." "Mr. Reed," I interrupted quietly, "I suggest you focus on your client's immediate legal situation. She's now facing assault charges in addition to her custody hearing." As officers led Vanessa away, still protesting her innocence, I learned the third betrayal. A court clerk who witnessed the incident revealed that Vanessa had been overheard earlier coaching Emma to tell Judge Carlton that Grandma says mean things about Mommy. This deliberate attempt to manipulate my granddaughter into lying cut deeper than the physical assault ever could. I made my way to the administrative judge's office, knowing that the morning's events would require immediate attention. The custody hearing would need to be postponed, and the entire situation reassessed in light of Vanessa's behavior. What I didn't yet realize was that this public incident would trigger a series of events that would place me in the most challenging ethical position of my judicial career, forced to choose between recusal and responsibility in a case that had suddenly become much more complex than a standard custody dispute. The administrative offices of the courthouse buzzed with unprecedented activity following the assault. Chief Judge Lawrence Blackwell, a normally unflappable man with 30 years on the bench, paced his office as I held an ice pack to my cheek. "Assaulting a judge in the courthouse, no less," he muttered, shaking his head. "In 28 years as chief, I've never seen anything like it." The county prosecutor had already been notified. Vanessa was being processed in the holding area, her custody hearing obviously postponed. Thomas Reed was frantically making calls, likely trying to secure her release before the assault charges were formally filed. "Catherine, I need to ask, do you want to press charges?" Judge Blackwell asked. "Is that really a question? She assaulted a judicial officer in a courthouse. Doesn't protocol require prosecution regardless of my personal preference?" He nodded grimly. "It does, but your position as the victim complicates things. Your relationship to the underlying custody case creates additional considerations. I hadn't even begun to process all the implications." The assault had occurred in front of numerous witnesses, including Judge Carlton, who had been walking toward his courtroom when Vanessa slapped me. Now he had witnessed firsthand an act of violence by one party in a case before him, potentially compromising his own impartiality. "William Carlton is requesting an emergency meeting," Judge Blackwell continued, confirming my concerns. Given what he witnessed, he's questioning whether he can remain objective. Within the hour, an unprecedented judicial conference convened in the Chief Judge's chambers. Judge Carlton, myself, Judge Blackwell, and Judge Rosario from the Ethics Committee sat around the imposing oak table, facing a situation none of us had encountered before. "I witnessed Miss Carson physically assault a respected colleague," Judge Carlton stated flatly. "I observed her making false accusations beforehand and showing no remorse afterward. I cannot in good conscience claim these observations won't influence my perception of her character and credibility in the custody matter." Judge Rosario, a meticulous jurist known for her expertise in judicial ethics, frowned thoughtfully. "Judge Carlton's candor is appropriate. The Code of Judicial Conduct requires recusal if a judge's impartiality might reasonably be questioned. But that creates a subsequent problem," Judge Blackwell pointed out. "We have 5 family court judges in this county. One is the assaulted party's mother-in-law." He nodded toward me. "One has now witnessed the assault and appropriately recused himself. Judge Harmon is on medical leave for at least 6 weeks. That leaves only Judges Martinez and Peterson." Judge Rosario's frown deepened, and Judge Peterson presided over the adoption of Miss Carson's niece last year, creating another potential conflict. "So we have one available judge for a high-conflict custody case," Judge Blackwell summarized. "And given the media attention this incident will inevitably receive, finding a judge from another county who hasn't heard about it will be challenging." The room fell silent as the unprecedented nature of our situation sank in. Family court cases, especially those involving young children, can't simply be put on hold indefinitely. Emma's well-being remained the paramount concern, regardless of her mother's behavior. "There is another option," Judge Rosario said carefully, though it's unusual. "Given the extraordinary circumstances, Judge Sullivan could potentially hear the case. I stared at her in disbelief. You can't be serious. I'm directly related to one party and was just assaulted by the other. Hear me out, she continued. The ethics rules provide that even when grounds for disqualification exist, a judge who would normally recuse may hear a case if the disqualification is remitted by the parties and their lawyers. Vanessa would never agree to that, I pointed out. And even if by some miracle she did, how could anyone believe I'd be impartial after what just happened? Judge Rosario leaned forward. Ordinarily, I would agree. But consider. The assault happened in full view of multiple witnesses. It's not a matter of conflicting accounts. The facts are established. More importantly, the assault demonstrates precisely why this case needs immediate attention. A parent who would commit violence in a courthouse shows concerning impulse control. The discussion continued for another hour, exploring every possible alternative. We considered bringing in retired judges, transferring the case to a neighboring county, or even asking the state Supreme Court for an extraordinary assignment. Each option presented logistical challenges and, more importantly, would further delay proceedings already critical for Emma's well-being. Eventually, Judge Blackwell made an administrative decision. I would be provisionally assigned to the case, with the understanding that both parties would be given the opportunity to object or consent after consultation with counsel. If either objected, we would pursue the complicated process of securing an out-of-county judge. I left the meeting with profound misgivings. Even with all parties' consent, presiding over my son's custody case seemed fundamentally problematic. Yet I also understood the practical reality. The system had limited resources, and a child's well-being hung in the balance. The day's final blow came when I returned home and found Michael waiting on my porch, his expression grave. I heard what happened, he said, embracing me carefully. Are you really okay? I'm fine, I assured him, more shocked than hurt. We sat in my living room as I explained the judicial assignment dilemma. His reaction surprised me. Mom, I think you should recuse yourself regardless of what the ethics committee says, he stated firmly. I plan to, I assured him. I just wanted you to understand why there might be delays in rescheduling. He shook his head. You don't understand. Vanessa will use this against me. She'll claim this whole incident was orchestrated, that you deliberately provoked her to prejudice her case, and now you're manipulating the system to appoint yourself as judge. That's absurd, I protested. There were dozens of witnesses. It doesn't matter. She'll create a narrative, and if you're the judge, every ruling against her becomes evidence of bias in her mind. His voice dropped. And what if the court ultimately rules in my favor? Vanessa will tell Emma for years that her grandmother abused judicial power to keep her from her mother. I felt the weight of his concern. Michael wasn't worried about the legal proceedings. He was worried about Emma's long-term relationship with both her mother and me. Later that evening, I received the fourth betrayal. A court clerk delivered a sealed affidavit Vanessa had prepared before the assault, making false claims that I had threatened and emotionally abused her throughout her marriage to Michael. The document was clearly prepared in advance, part of a calculated strategy rather than a spontaneous reaction. As I sat in my home office reviewing family court precedents late into the night, the magnitude of the situation settled upon me. This was no longer just about a custody dispute or even an assault. It had become a test of the judicial system itself, whether justice could prevail when personal and professional boundaries were being deliberately blurred by someone willing to manipulate truth for their own ends. The decision I would make in the coming days would affect not only my family and career, but potentially set precedent for how similar situations might be handled in the future. The responsibility weighed heavily, keeping me awake long after I should have found rest. Sleep eluded me that night. I tossed and turned, replaying the courthouse confrontation in my mind. The sting of Vanessa's slap had faded, but the implications of the day's events grew more complex with each passing hour. By 4 a.m, I gave up on rest and moved to my study, surrounded by law books that had guided my career but offered no clear path through this unprecedented situation. 20 years on the bench had trained me to separate personal feelings from judicial duty. I had heard cases involving friends, children, former neighbors, and even my own former piano teacher without allowing those connections to influence my rulings. But this was different, a direct family connection, compounded by becoming the victim of a crime committed by one of the parties. As dawn broke, I found myself pulling out photo albums from the shelf. There was Michael on his 5th birthday, gap-toothed grin and chocolate-smeared cheeks. Michael graduating medical school, his face a mixture of pride and grief that his father hadn't lived to see the achievement. Michael holding newborn Emma, looking at her with awe and terror in equal measure. And then there were the newer photos: Emma building sandcastles at the beach, Emma on my shoulders at the zoo, Emma carefully arranging her tea party guests, which included her favorite stuffed rabbit and me, in precise order. These memories weren't just sentimental. They represented real relationships that would be affected by whatever happened next. My judicial oath required impartiality, but was true impartiality even possible here? Could any human being, no matter how committed to justice, truly set aside the complex emotions involved when ruling on their own grandchild's future? At 7, I called Eleanor Hammond, the retired judge who had mentored me when I first took the bench. Now, in her 70s, Eleanor's mind remained sharp as ever, her ethical compass unwavering. "Catherine," her voice was warm even at this early hour. "I've already heard about the incident. Are you all right?" "Physically, yes," I admitted. "Ethically, I'm in uncharted territory." I explained the situation: Judge Carlton's recusal, the limited judicial resources, the proposal that I potentially hear the case. Eleanor listened without interruption, a habit from her decades on the bench. "In 40 years of judicial service, I never encountered this precise scenario," she finally said. "But the principles remain the same. Justice must not only be done, but be seen to be done. So you think recusal is the only option?" "I didn't say that." Her response surprised me. "The question isn't whether you have connections to the case. Clearly you do. The question is whether you can render a fair judgment based solely on the evidence presented, and whether a reasonable observer would believe you capable of doing so." "How could anyone reasonably believe I'd be impartial toward the woman who just assaulted me?" Eleanor's reply was measured. "Consider this. If Vanessa had slapped a different judge, would that judge be expected to rule in her favor to prove impartiality? Of course not. The assault is now evidence of her temperament and judgment, legitimately relevant to a custody determination. But I'm not just any judge, I'm Michael's mother." "True," Eleanor acknowledged. "Which is why the consent of both parties is essential. But Catherine, consider this. If you recuse, and the case is delayed for months seeking another judge, who suffers most?" The answer was immediate: Emma. Every week of uncertainty meant more tension, more anxiety for a 4-year-old already showing signs of emotional distress. The judicial system sometimes requires us to step into uncomfortable roles when the alternatives would cause greater harm, Eleanor continued. If and only if both parties consent after proper counsel, taking this case may be the least damaging option for your granddaughter. After we hung up, I sat with her words, turning them over in my mind. Was I considering this option because it was truly best for Emma, or was I rationalizing a choice that would give me control over a situation that had spun so dramatically out of control? I spent the morning reviewing the case file with painstaking attention. The evidence was substantial. Michael's documentation of his parenting time and Emma's behavioral changes, witness statements about Vanessa's erratic behavior, preliminary reports from interviews with Emma's preschool teachers. If this were any other case, the evidence would strongly favor Michael. But this wasn't any other case, and I couldn't trust my own assessment. Would I be harder on Michael to prove my impartiality? Would I be unconsciously biased against Vanessa after the assault? These questions had no easy answers. My phone rang again, Michael calling. His voice sounded strained. "Mom, I've been thinking about the situation. I want to formally request that you recuse yourself, regardless of what the ethics committee says is permissible." Though I had been leaning toward recusal myself, his request stung unexpectedly. "I understand," I said carefully. "May I ask what prompted this decision?" "My attorney thinks any ruling you make in my favor would be vulnerable to appeal. And honestly, Mom, I'm worried about you. The scrutiny will be intense. The media is already calling this a judicial family feud. I don't want to put you in that position." His concern for me, even amid his own crisis, brought tears to my eyes. "Michael, I appreciate that. But my career can withstand scrutiny. What matters is what's best for Emma." "That's just it," he replied. If this drags on with challenges and appeals because you were the judge, it only extends her uncertainty. A neutral judge might take longer to appoint, but their ruling would be more likely to stick. His logic was sound, his concern genuine. Yet something in his voice suggested there was more he wasn't saying. "Michael, is Vanessa pressuring you about this?" The pause before his answer told me everything. Her lawyer called mine. "They're offering a more generous visitation schedule if we agree to request an out-of-county judge. They're implying they have more information about judicial misconduct they might not need to use if we cooperate." The blackmail was thinly veiled but clear. I felt a flash of anger not for myself, but for my son being manipulated this way. "Michael, you shouldn't make decisions based on threats. I know, Mom, but I also know Vanessa. She'll burn everything down around her before admitting she's wrong. I just want what's best for Emma." After we hung up, I sat with the weight of his request. My instinct was to protect my son from Vanessa's manipulation, to use my position to ensure justice was served quickly and fairly. But wasn't that precisely the conflict of interest that recusal was designed to prevent? As I prepared for my regular court calendar that afternoon, I learned of the fifth betrayal. Courthouse gossip revealed that Vanessa had hired a private investigator to review all of my previous custody rulings, looking for patterns she could use to claim gender bias. She was attempting to build a case that I systematically favored fathers in custody disputes, a claim easily disproven by court records but potentially damaging in the court of public opinion. This calculated attempt to attack my judicial record rather than address the legitimate concerns about her parenting clarified something important. Vanessa viewed the legal system not as a path to justice but as an obstacle to be manipulated or circumvented. Her willingness to manufacture claims of judicial impropriety demonstrated precisely the kind of character that would be relevant in a custody determination. That evening, I made my decision. I would not automatically recuse myself, despite Michael's request. Instead, I would follow the process outlined by Judge Rosario. Both parties would receive formal disclosure of all potential conflicts, consult with counsel, and have the opportunity to object or consent to my presiding. If either objected, I would step aside without question. But I would not allow Vanessa's intimidation tactics to short-circuit proper judicial procedure. Too much was at stake, not just Emma's well-being, but the integrity of a system designed to protect children from precisely the kind of manipulative behavior Vanessa was displaying. As I drafted the formal disclosure document, I reflected on the core principle that had guided my judicial career. Justice requires not just fairness, but the courage to make difficult decisions when easier paths might compromise the ultimate goal of serving truth. Whether I ultimately heard this case or not, I would ensure that the process itself maintained the integrity that Emma's future deserved. The document complete, I placed it in my briefcase for filing in the morning. Whatever came next, I was prepared to face it with the same commitment to justice that had defined my 20 years on the bench. Emma deserved nothing less. 3 days after the courthouse incident, the impossible happened. Both parties consented to my presiding over the case. Michael agreed reluctantly, influenced by the significant delays the alternatives would create. Vanessa's consent came as a complete surprise, until her attorney's statement clarified her strategy. "My client wishes to demonstrate her confidence that even Judge Sullivan, despite recent events, will recognize her superior parenting claims when presented with all evidence." It was a calculated move. If I ruled against her, she could claim bias. If I ruled for her despite our history, she would appear vindicated. Either way, she believed she had positioned herself advantageously. The Ethics Committee provided specific guidelines. The case would receive heightened scrutiny, with detailed written findings required for each determination. All hearings would be transcribed verbatim rather than summarized. Judge Rosario would review the proceedings as they progressed to ensure continued adherence to judicial standards. With these safeguards in place, the custody hearing was rescheduled for the following Monday. I spent the weekend reviewing family court precedents and consulting with Judge Rosario on maintaining impartiality in high-conflict cases. I deliberately avoided all contact with Michael, even declining his Sunday phone call, a painful but necessary step to preserve judicial distance. Monday morning arrived with unusual tension in courtroom 3B. Court officers had implemented additional security measures, with 2 officers present rather than the usual one. The gallery contained more spectators than typical for a family court, preceding a few journalists, several attorneys observing out of professional interest, and a sprinkling of courthouse staff curious about the unprecedented situation. I entered precisely at 9, the familiar ritual of all rise providing a momentary sense of normalcy. As I took my seat, I surveyed the courtroom. Michael sat beside his attorney, Jennifer Hayes, looking exhausted but composed in a conservative navy suit. Across the aisle, Vanessa projected confident elegance in a cream-colored dress and jacket, her expression inscrutable. Thomas Reed had assembled a 3-person legal team at their table, a show of force for what would typically be a straightforward custody hearing. Before we proceed, I began. I want to address the unusual circumstances of this hearing. My voice remained steady, professional. 4 days ago, an incident occurred between myself and Miss Carson in the courthouse corridor. That incident has been documented and is subject to separate criminal proceedings. It will not be referenced during this hearing except as it directly pertains to the custody determination before us. I continued. Both parties have been advised of potential conflicts of interest and have consented in writing to my presiding over this matter. This consent has been reviewed and approved by the Judicial Ethics Committee. Throughout these proceedings, I will apply the same standards of evidence and legal reasoning that would govern any custody determination in this court. Thomas Reed stood immediately. Your Honor, we appreciate your commitment to impartiality. However, my client wishes the record to reflect her continuing concerns about family influence in these proceedings. Noted, I replied evenly. The record will also reflect that Miss Com's mission the nation. Carson has been provided with all appropriate procedural protections, including the opportunity to object to my assignment to this case, which she declined to exercise. Reed nodded, seemingly satisfied with having established his objection for the record. Jennifer Hayes began Michael's case with methodical precision. She outlined his consistent involvement in Emma's life, his adjustments to medical practice hours to accommodate parenting time, and his stable home environment. Michael's testimony was straightforward and child-focused, emphasizing Emma's needs rather than criticizing Vanessa. Dr. Sullivan, Hayes asked, please describe your typical evening routine with Emma. Michael detailed bedtime stories, toothbrushing songs, and the special stuffed penguin that helped Emma transition to sleep. His description matched what I had observed during Emma's visits to my home, but I carefully maintained judicial detachment, evaluating his testimony as I would any witnesses. Character witnesses for Michael included his medical partner, Emma's godmother, and 2 preschool teachers who testified to his consistent involvement in school activities and appropriate responses to Emma's developmental challenges. Each witness faced rigorous cross-examination from Reed, who attempted to portray Michael as work-obsessed and Emma's recent behavioral issues as reactions to his parenting rather than Vanessa's. Throughout the morning, I maintained scrupulous fairness in evidentiary rulings, allowing Reed considerable latitude in questioning while ensuring Hayes had equal opportunity. When Reed attempted to introduce hearsay about my relationship with Emma, I sustained Hayes's objection with the same even-handed explanation I would provide in any case. After lunch recess, Vanessa took the stand, presenting herself as a devoted mother unfairly maligned by her former in-laws. Her testimony painted Michael as distant and critical, herself as Emma's primary emotional support. She described elaborate birthday parties, mommy and me classes, and specialized nutrition plans she had developed for Emma. Miss Carson, Reed guided, how would you characterize Emma's relationship with her father? Emma loves her father, Vanessa replied carefully, but she gets anxious before visits with him. She tells me his house is boring and he spends too much time on his phone. This directly contradicted Michael's documented involvement and the teacher's testimony about Emma's enthusiasm when Michael participated in school activities. During cross-examination, Hayes methodically highlighted inconsistencies in Vanessa's testimony. Presented with her own text messages complaining about having to babysit my own kid when Michael had emergency surgeries, Vanessa grew defensive. Those messages are being taken out of context, she insisted. I was just having a bad day. And how many bad days resulted in you leaving Emma with various friends without notifying Dr. Sullivan? Hayes pressed. I've always ensured Emma had proper care, Vanessa responded, her composure slipping slightly. Sometimes, arrangements need to be flexible. The court-appointed psychologist, Dr. Sarah Jensen, provided expert testimony about her evaluations of Emma and both parents. Her assessment favored Michael, noting Emma's more relaxed behavior in his presence and concerning patterns in her interactions with Vanessa. In observed sessions, Emma showed heightened anxiety about saying the wrong thing in Miss Carson's presence, Dr. Jensen testified. She frequently looked to her mother for approval before answering simple questions about her preferences or activities. As Dr. Jensen detailed her observations, I noticed Vanessa whispering urgently to Reed. Her expression had shifted from composed to increasingly agitated as the expert testimony undermined her narrative. When court recessed for the day, I reminded all parties of the confidentiality requirements and emphasized that no discussion of the proceedings should occur with Emma. The warning was standard in custody cases but felt particularly necessary given the tension in the courtroom. In my chambers afterward, Martha Reynolds, my longtime court reporter, provided unexpected moral support. "Judge Sullivan," she said quietly as she gathered her equipment, "I've transcribed thousands of hours in your courtroom. I've never seen anyone maintain such impartiality under these circumstances." Her comment from someone who had observed countless judges over a 30-year career provided reassurance that I was successfully navigating this unprecedented situation. Martha became my first ally in this challenging process, her professional validation confirming that judicial ethics could indeed prevail over personal connection when approached with sufficient care. As I drove home that evening, I reflected on the day's testimony. The factual record was building toward a clear determination, but we were only halfway through the scheduled witnesses. Vanessa's increasingly defensive responses suggested she recognized the direction of the evidence. This raised my concern about what tactics she might employ as her position weakened. The custody hearing was accomplishing its purpose, creating a thorough record on which a determination of Emma's best interests could be based. But Vanessa's reaction to unfavorable testimony hinted at potential escalation. Having already demonstrated a willingness to cross ethical and legal boundaries, what might she do when facing the prospect of losing primary custody of Emma? I couldn't have anticipated just how desperate her measures would become, or how they would test not just my judicial objectivity, but the integrity of the entire proceeding. The following day would push the boundaries of courtroom decorum to breaking point, requiring every ounce of judicial discipline I had developed over 20 years on the bench. The second day of the hearing began with a subtle shift in Vanessa's demeanor. Gone was the composed confidence of the previous day, replaced by a tightly controlled intensity that experienced judges recognize as potential trouble. She entered the courtroom with shoulders squared, whispering urgently to Reed as they took their seats. The morning proceeded with testimony from Emma's pediatrician, who confirmed Michael's consistent attendance at medical appointments and appropriate attention to Emma's health needs. This contradicted Vanessa's claim that Michael was uninvolved in medical decisions, further undermining her credibility. During cross-examination, Reed's strategy became apparent. Rather than addressing the substance of the pediatrician's testimony, he focused on establishing that the doctor had attended medical school with Michael, insinuating professional bias. When this approach gained little traction, Vanessa's frustration became visible in her rigid posture and whispered comments to her attorney. The shift from composed to confrontational occurred during the testimony of Emma's babysitter, who described an incident when Vanessa returned 3 hours late from a dinner, appearing intoxicated and becoming belligerent when the babysitter expressed concern. "Objection." Reed stood abruptly. "This witness is clearly biased against my client. We have evidence of Miss Sullivan's inappropriate influence." "Basis for the alleged bias, Mr. Reed?" I inquired evenly. Reed approached the bench with a folder. "Your Honor, we have photographs showing this witness attending a birthday party at your home 6 months ago. She has a personal relationship with the Sullivan family." I reviewed the photographs from Emma's 4th birthday party, a public event at a local park where many of Emma's friends and caregivers had gathered. The babysitter's presence was entirely appropriate given her role in Emma's life. "Mr. Reed, attendance at a child's birthday celebration doesn't constitute bias. Many of Emma's caregivers were present at this public event." Objection overruled. Vanessa shook her head vehemently, whispering something that made Reed sigh before returning to his seat. Her eyes narrowed as she stared at me, the hostility palpable across the courtroom. Following the morning recess, Reed attempted a new strategy, seeking to introduce text messages allegedly showing me making disparaging comments about Vanessa to Michael. I examined the purported evidence carefully. Mr. Reed, these messages appear to be edited screenshots without proper authentication. Further, they lack context and complete message threads. The court cannot admit unauthenticated, potentially altered communications. Your Honor, Reed persisted, these messages demonstrate bias that directly impacts these proceedings. Even if authenticated, Mr. Reed, private communications between family members prior to these proceedings would be relevant only if they demonstrated actual judicial misconduct, which these fragmentary, unauthenticated screenshots do not. Objection sustained. Vanessa's reaction was immediate and theatrical. She stood abruptly, her chair scraping loudly against the floor. This is exactly what I expected. You're excluding evidence that exposes your bias. Miss Carson, I warned, maintaining an even tone, outbursts are not permitted. Please be seated, or you will be held in contempt. Of course you'd threaten me, she retorted. You've been trying to take Emma from me from day one. Everyone in this courtroom knows this whole proceeding is rigged. Miss Carson, this is your final warning. Sit down and allow these proceedings to continue in an orderly manner. Reed placed a restraining hand on Vanessa's arm, murmuring urgent advice. She shrugged him off but reluctantly sat, her expression mutinous. This court will take a 15-minute recess, I announced. I suggest counsel use this time to confer with their clients about appropriate courtroom behavior. In my chambers, I took several deep breaths, centering myself before the proceedings resumed. Vanessa's outburst wasn't surprising. I'd seen similar reactions from litigants facing unfavorable evidence, but the personal nature of her accusations required extra diligence in maintaining judicial detachment. When court reconvened, Reed requested a sidebar conference. Your Honor, I apologize for my client's outburst. She's under tremendous stress, but understands the need for decorum. We request the opportunity to present additional character witnesses. Request granted, Mr. Reed. The court is committed to hearing all relevant evidence. The afternoon proceeded with Vanessa's witnesses' friends who testified to her devotion to Emma, her involvement in preschool activities, and her efforts to provide enriching experiences. Cross-examination revealed that several of these witnesses had limited first-hand knowledge of Vanessa's day-to-day parenting, primarily seeing her at planned social events rather than in routine caregiving situations. As the evidence continued mounting against her position, Vanessa grew visibly agitated. When Hayes effectively challenged a witness's account of Vanessa's parenting consistency, I noticed Vanessa scribbling furiously on a notepad, then passing it to Reed with an insistent gesture. He read it, shook his head firmly, and returned to his questioning. The breaking point came during the testimony of the court-appointed guardian ad litem, whose role was to represent Emma's interests independently. Her assessment echoed Dr. Jensen's concerns about Vanessa's parenting. In my observations, Miss Carson's interactions with Emma often seemed performance-oriented rather than responsive to Emma's needs, the guardian testified. Emma appeared anxious about pleasing her mother, while interactions with Dr. Sullivan were more relaxed and age-appropriate. As the guardian described specific examples, Vanessa suddenly interrupted. This is absurd. She spent barely an hour with me and Emma. Judge Sullivan has poisoned everyone against me. She's even told Emma that Mommy is a bad person. Miss Carson. I used the sharper tone reserved for serious courtroom disruptions. This behavior is contemptuous. One more outburst and you will be removed from these proceedings. Instead of heeding the warning, Vanessa escalated dramatically. Everyone here is pretending this is a fair hearing when the judge is literally the grandmother who wants to steal my child. She's always hated me. She's been working with Michael to take Emma since our separation. Bailiff. I directed calmly, please escort Miss Carson from the courtroom. Mr. Reed, you may continue representing your client's interests in her absence. As the bailiff approached, Vanessa's strategy shifted from disruption to shocking personal attack. Judge Sullivan emotionally abused me throughout my marriage. She told Michael I wasn't good enough for him. She undermined my parenting at every turn. These false allegations, similar to those in the pre-prepared affidavit, were clearly designed to create a scene that would potentially force a mistrial. The courtroom fell silent, as the bailiff gently but firmly escorted a now sobbing Vanessa toward the door. Reed immediately moved for a mistrial. Your Honor, given the extreme emotional nature of these proceedings and my client's serious allegations, we believe continuing under these circumstances compromises due process. Motion denied. Mr. Reed, I ruled firmly. Your client's deliberate disruption of proceedings after repeated warnings does not constitute grounds for a mistrial. The court will take a 30-minute recess, after which we will continue with the remaining testimony. In my chambers, I documented the incident in detail, knowing the unusual circumstances required meticulous record-keeping. Court Security Officer Wilson knocked on my door. Judge Sullivan, I thought you should know. I overheard Miss Carson in the hallway before her outburst, telling someone on her phone that she was going to create a scene they couldn't ignore and force a new judge to be assigned. This information confirmed my assessment that Vanessa's outburst had been strategic rather than emotional, a calculated attempt to derail proceedings that weren't going her way. Thank you, Officer Wilson. Would you be willing to provide a written statement about what you overheard? He nodded. Already prepared one, Judge. Figured it might be important given the situation. Martha, my court reporter, had remained in the courtroom during the recess, organizing her equipment. When I returned, she offered unexpected support. Judge Sullivan, I've been a court reporter for 32 years. I've never seen anyone maintain such judicial composure in the face of personal attacks. The record will show your complete professionalism throughout this difficult proceeding. Her words from someone who had observed thousands of hours of judicial conduct provided valuable validation. Martha became my first ally in this challenging process, her professional assessment confirming that I was successfully navigating an unprecedented situation. When proceedings resumed, Reed continued without Vanessa, calling their final witnesses and making closing arguments that emphasized Vanessa's love for Emma while attempting to contextualize her courtroom behavior as a mother's desperate concern. Hayes presented a measured closing argument, focusing on evidence rather than emotion, emphasizing Michael's consistent caretaking and Emma's need for stability. Throughout the afternoon, I maintained strict judicial demeanor, neither showing sympathy toward Michael nor harboring resentment toward Vanessa. Every ruling, every question, every procedural decision adhered rigorously to established standards. The personal attack had not achieved its intended effect. The proceedings continued with appropriate judicial dignity and focus on Emma's best interests. As court adjourned for the day, with only final arguments remaining the following morning, I knew Vanessa's desperate measures had backfired. Rather than creating grounds for mistrial, she had provided additional evidence of precisely the concerning behavior that witnesses had described: impulsivity, manipulation, and willingness to create conflict regardless of impact on Emma. In my chambers afterward, reviewing my notes in preparation for crafting a detailed custody ruling, I reflected on the day's events. Vanessa's strategy had been transparent. When evidence didn't support her position, she attempted to undermine the process itself. This pattern, attacking the system rather than addressing legitimate concerns about her behavior, spoke volumes about her approach to parenting and conflict resolution. The following day would bring final arguments, and my ruling a decision that would profoundly impact Emma's future. Despite the extraordinary circumstances and personal attacks, judicial ethics had prevailed throughout the proceedings. Now the most important task remained: rendering a decision based solely on evidence and law, completely independent of the familial connection that had made this case unprecedented. The courtroom was unusually full on the final morning of the hearing. Word had spread about Vanessa's dramatic exit, drawing additional spectators interested in the conclusion of this unprecedented case. Several family court judges from neighboring counties had taken seats in the back row, their presence a silent acknowledgement of the case's significance for judicial ethics. Vanessa had returned, subdued and carefully styled in a conservative navy dress that mimicked typical courtroom attire. The strategic shift was obvious, from confrontational to contritely professional. Reed had clearly coached her on presenting a more favorable final impression. Before we proceed with closing arguments, I began. I want to address yesterday's disruption. Miss Carson, your behavior was inappropriate and contemptuous. However, this court's focus remains on determining custody arrangements that serve your daughter's best interests. That determination will be based on evidence and applicable law, not on courtroom behavior, however concerning. This measured response, acknowledging the disruption while reaffirming focus on legal standards, established that neither Vanessa's outburst nor her newly subdued demeanor would unduly influence the proceedings. Closing arguments proceeded without incident. Reed emphasized Vanessa's role as Emma's mother, her involvement in early development, and her commitment to providing enriching experiences. He characterized the negative testimony as exaggerated and influenced by family loyalty to Michael. His presentation was skillful, extracting the most favorable interpretation from sometimes problematic evidence. Hayes focused on the documented pattern of Michael's consistent caregiving, contrasted with Vanessa's erratic behavior. She emphasized the expert testimony regarding Emma's anxiety around her mother and comparative comfort with her father. Rather than attacking Vanessa personally, she maintained focus on Emma's demonstrated needs for stability and emotional security. Following these arguments, I announced I would deliver my ruling that afternoon, after thoroughly reviewing all testimony and evidence. This brief recess was standard procedure in contested custody cases, allowing careful consideration of all factors, but took on additional significance given the case's unusual circumstances. In my chambers, I methodically reviewed my notes, the guardian ad litem's recommendations, and the applicable legal standards. The best interests of the child doctrine that governs custody determinations encompasses multiple factors: stability, emotional bonds, parental capacity, and developmental needs, among others. I drafted detailed findings addressing each factor, ensuring every determination was supported by specific evidence from the record. When court reconvened at 2 o'clock, the tension was palpable. Michael sat with perfect posture, hands folded on the table before him. Vanessa repeatedly tucked her hair behind her ears, a nervous gesture I'd noticed during particularly stressful testimony. Both attorneys maintained professional composure, though Hayes occasionally glanced at Michael with reassuring confidence. This court has carefully considered all evidence presented regarding the custody of Emma Sullivan Carson, I began, using the formal case caption rather than familiar references. Custody determinations are among the most consequential decisions this court makes, with long-lasting impact on children's development and well-being. I proceeded methodically through each factor in the best interest standard, connecting specific evidence to each determination. When discussing stability, I cited Michael's consistent routine and Vanessa's documented pattern of unpredictable scheduling. Regarding emotional security, I referenced the expert testimony about Emma's anxiety in Vanessa's presence contrasted with her relaxed behavior with Michael. Particularly concerning to this court, I continued, is the evidence suggesting Miss Carson has attempted to influence Emma's statements about her father and extended family. The court-appointed psychologist documented multiple instances where Emma appeared to recite practice negative comments about Dr. Sullivan, followed by looking to Miss Carson for approval. Vanessa shifted uncomfortably, whispering urgently to Reed, who gently shook his head. She had clearly anticipated this finding, but remained visibly upset by its public articulation. Conversely, there is substantial evidence that Dr. Sullivan has refrained from making negative comments about Miss Carson in Emma's presence, instead focusing on maintaining supportive co-parenting despite personal conflicts. Multiple witnesses, including Emma's teachers and caretakers, testified to Dr. Sullivan's consistent positive approach. I continued through remaining factors: parental capacity, involvement in education and activities, appropriate boundary setting, and fostering development. On most factors, the evidence favored Michael, though I explicitly acknowledged areas where Vanessa had demonstrated positive involvement. Having weighed all statutory factors and considered the totality of evidence presented, this court finds that Emma's best interests will be served by awarding primary physical custody to Dr. Michael Sullivan, with substantial visitation rights for Miss Vanessa Carson. Vanessa gasped audibly, her composure cracking despite obvious efforts to maintain it. Michael remained still, his only reaction a slight relaxing of his shoulders. Regarding visitation, I continued, the court orders progressive implementation, beginning with supervised visitation 3 times weekly for 1 month, followed by unsupervised daytime visits if deemed appropriate by the court-appointed supervisor. Overnight visitation may commence after 3 months of successful daytime visits, contingent on Miss Carson's completion of a parenting class focused on age-appropriate emotional support. This graduated approach was designed to maintain Emma's relationship with Vanessa while addressing the legitimate concerns about her parenting approach. The structure provided Vanessa opportunity to demonstrate improved parenting skills while ensuring Emma's emotional security during the transition. As I detailed the specific schedule and conditions, Vanessa's control finally broke. "This is exactly what I expected from the beginning," she interrupted, rising from her seat. "Of course you'd give Emma to your precious son, Miss Carson." I responded firmly. "This ruling is based entirely on evidence presented during these proceedings. Your continued disruptions only underscore concerns about emotional regulation that were documented by multiple witnesses. You've never given me a fair chance," she continued, voice rising. "This whole process has been corrupted by your influence." Reed attempted to calm his client, whispering urgently while gripping her arm. She shrugged him off, fully committed to her performance. "I demand a mistrial. No reasonable person would believe this proceeding was impartial. Miss Carson, your objections are noted for the record," I responded, maintaining judicial composure. "If you wish to appeal this ruling, that is your right. However, further disruption of these proceedings will result in contempt charges." What happened next changed the entire trajectory of the case. Officer Wilson approached the bench, carrying a tablet. "Your Honor, excuse the interruption, but there's something you need to see immediately." I called a brief recess and reviewed the content on the tablet in my chamber's security footage from the courthouse hallway taken 30 minutes before the day's proceedings began. The video clearly showed Vanessa speaking with Emma in a secluded corner, instructing her, "Remember what we practiced. Tell the judge that Grandma says mean things about me and makes you sad. If you do this right, you'll get to live with Mommy all the time." When court reconvened, I addressed the unexpected evidence. The court has received security footage relevant to these proceedings. This footage shows Miss Carson coaching Emma to make false statements about Judge Sullivan, with explicit promises of custody rewards for compliance. Vanessa's face drained of color as the courtroom murmured in shock. Reed appeared genuinely blindsided, staring at his client with undisguised dismay. "This footage will be entered into evidence and made available to both attorneys immediately," I continued. "Given this development, the court orders an immediate cessation of Miss Carson's contact with Emma pending investigation of potential witness tampering, which is a criminal offense." The revelation transformed Vanessa's theatrical indignation into genuine panic. "I was just preparing her," she protested. "Michael's been coaching her for months." "Miss Carson," Reed interjected urgently, "I advise you to stop speaking immediately." But Vanessa, now truly desperate, continued, "Everyone's against me. Catherine's always hated me. She's poisoned everyone. Even you," she accused Reed. "None of you understand what it's like to have your child stolen by these people." As court officers moved toward Vanessa, she abruptly collapsed into her chair, the fight visibly leaving her. Fine, you win," she murmured, addressing me directly. "You've always wanted Emma for yourselves, the perfect little Sullivan family." In this moment of defeat, Vanessa revealed more about her perspective than any testimony had. She genuinely viewed this as a competition between families rather than a determination of Emma's best interests, a fundamental misunderstanding of both parental responsibility and the legal process. "This court's ruling stands," I concluded, with the additional provision that Miss Carson's visitation will remain supervised until further order, based on this new evidence of attempted witness manipulation. Court is adjourned. As people filed out of the courtroom, Judge Carlton approached the bench. "Catherine, I observed most of the proceedings these past 3 days. Your handling of this unprecedented situation has been exemplary." His public statement of support from the judge who had originally recused himself after witnessing Vanessa's assault provided important professional validation. Judge Carlton became my second ally, his experienced assessment confirming that judicial ethics had prevailed despite extraordinary personal challenges. Michael remained seated long after others had departed, seemingly overwhelmed by the proceedings' conclusion. When we were alone, except for court staff, he finally spoke. "I never wanted it to come to this," he said quietly. "I just wanted Emma to be safe and happy." "I know," I replied, maintaining appropriate judicial distance despite the personal moment. The court's ruling provides a framework for that to happen. As I gathered my files and prepared to leave the courtroom, I reflected on the extraordinary case that had just concluded. Despite Vanessa's multiple attempts to undermine the process, from ethics complaints to courtroom disruptions to witness tampering, the system had functioned as intended. Evidence had been evaluated, statutory factors applied, and a determination reached based on legal standards rather than personal connections. The unexpected security footage had merely confirmed what witness testimony had already established: Vanessa's willingness to manipulate Emma for personal advantage, with little regard for her emotional well-being. The revelation had been dramatic, but ultimately aligned with the pattern already documented through proper judicial process. In my chambers, I completed the formal written ruling that would establish the custody framework for Emma's future. Despite the personal connection that had made this case unique, the outcome rested on the same foundation as every custody determination I had made over 20 years on the bench: careful evaluation of evidence, application of established legal standards, and unwavering focus on a child's best interests. 6 months passed before I saw Vanessa again outside of formal court proceedings. The criminal charges stemming from the courthouse assault had been resolved through a plea agreement involving community service and anger management classes. The custody arrangement had proceeded as ordered, with Vanessa completing parenting classes and progressing from supervised to unsupervised visitation after demonstrating improved interactions with Emma. The transformation in my granddaughter was remarkable. The anxious, people-pleasing child had gradually relaxed into a more age-appropriate exuberance. Her preschool teachers reported significant improvements in social interaction and emotional regulation. Though she still experienced occasional anxiety during transitions between households, the consistency of the custody schedule had provided much-needed stability. Michael had adjusted to single fatherhood with the dedication I had always observed in him, creating a nurturing routine while maintaining open communication with Vanessa about Emma's activities and development. He never spoke negatively about Vanessa in Emma's presence, modeling the respectful co-parenting that research consistently shows benefits children of separation. I had maintained appropriate boundaries, recusing myself from any subsequent legal matters involving Michael and Vanessa while gradually resuming normal grandparent activities with Emma. The ethical firewall between my judicial role and family relationship had been carefully reconstructed, with transparent documentation of all decisions. The unexpected encounter with Vanessa occurred at Emma's dance recital. I had deliberately arrived early to select a seat distanced from where Michael and Vanessa would be sitting, maintaining the separation that had characterized all Emma-related events since the custody ruling. I was reviewing the program when a voice spoke quietly beside me: Judge Sullivan. Vanessa stood in the aisle, hands clasped nervously before her. Gone was the confrontational posture and entitled expression I had come to expect. She appeared genuinely uncomfortable but determined. "May I speak with you for a moment?" she asked, gesturing to an empty seat beside me. Professional caution warred with human curiosity. Briefly, I agreed. Emma's class performs soon. Vanessa sat carefully, maintaining formal distance. I've been wanting to say this for months, but my pride. She paused, visibly gathering courage. I'm sorry for what happened at the courthouse. The assault, the accusations, all of it. It was inexcusable. The apology was unexpected. Vanessa had maintained righteous indignation throughout the legal proceedings, framing herself as the victim of judicial bias even after the custody ruling. What prompted this change of perspective? I asked, neither accepting nor rejecting the apology yet. The parenting classes, partly, she admitted. But mostly the therapy I've been doing. I've had to face some uncomfortable truths about myself and my behavior. She glanced toward the stage where children were gathering for the performance. And seeing how much happier Emma is now, I can't deny the current arrangement is working better than when I was trying to exclude Michael from her life. Her self-awareness surprised me. That's a significant realization. It hasn't been easy, Vanessa continued. For so long, I viewed you and Michael as the enemy, conspiring to take Emma away. I convinced myself any action was justified to prevent that. It's taken months of therapy to recognize that pattern, how I created the very situation I feared by trying to control everything. The conversation paused as Emma's class took position on stage. We both watched as Emma performed her routine with obvious joy, waving excitedly when she spotted both of us in the audience. She deserves parents who can cooperate, Vanessa said softly as the performance ended. I'm trying to become that kind of mother, even if it's coming later than it should have. That's commendable, I replied, genuine in my assessment. Emma benefits from having both parents fully engaged in her life. Would you? Vanessa hesitated, uncharacteristically uncertain. Michael has invited me to join you all for dinner after the recital, to celebrate Emma's performance together. Would that be uncomfortable for you? The invitation represented a significant shift, Michael extending an olive branch, Vanessa accepting it, both prioritizing Emma's experience over their conflict. I think Emma would be delighted to have everyone she loves celebrating together, I answered carefully. If you and Michael are ready for that step, I can certainly join you. The dinner that followed was initially awkward, but gradually eased into civil conversation, focused primarily on Emma's accomplishments and interests. Michael and Vanessa coordinated summer activity plans with minimal tension. I observed more than participated, witnessing the tentative formation of a new kind of family structure, separated but collaborative, prioritizing Emma's well-being over personal grievances. As we prepared to leave the restaurant, Emma's excited chatter about her upcoming birthday created an unexpected moment of consensus. Maybe we could have one party this year, Vanessa suggested tentatively, instead of separate celebrations. At the park again? Michael asked, glancing at me with shared memory of the previous year's event, the same gathering Vanessa had tried to use as evidence of bias during the hearing. That would be nice, Vanessa agreed. Emma should have all her family together for important moments. 3 weeks later, Emma's 5th birthday brought together an unlikely gathering. Michael and Vanessa coordinated decorations and activities with surprising cooperation. Friends, classmates, and family members from both sides mingled in the park where tension had once been palpable between the adults in Emma's life. Watching Emma blow out her candles, surrounded by people who had once been bitterly divided, I reflected on the extraordinary journey of the past year. The custody case had been professionally challenging and personally painful, testing the boundaries between judicial duty and family loyalty. Yet somehow, through strict adherence to ethical principles and the passage of time, a new equilibrium had emerged. As a family court judge for over 20 years, I had presided over hundreds of custody disputes, always emphasizing that cooperation benefits children more than legal victory. Rarely had I witnessed such dramatic transformation from conflict to collaboration. Though unusual circumstances had placed me in the dual role of judge and family member, the core principles of family law had ultimately prevailed. A child's best interests served through adults setting aside personal grievances to focus on providing stability and support. The relationship between Michael and Vanessa remained formally structured, their interactions guided by the custody agreement rather than emotional connection. But the hostility had dissipated, replaced by a pragmatic partnership focused on Emma's well-being. My own relationship with Vanessa had evolved from adversarial to cautiously respectful, our shared concern for Emma creating common ground where none had seemed possible. As a judge, I had always instructed separating parents that forgiveness and cooperation serve children better than vindication and victory. Now, through this unexpected personal journey, I had experienced firsthand the wisdom of that judicial guidance. Emma's improved emotional state and developmental progress validated the difficult decisions and boundaries that had been necessary throughout the process. The custody ruling that had once seemed to finalize conflict had instead become the foundation for an unexpected healing, not erasing past wrongs, but creating structure for moving forward in a healthier way. The slap that had triggered unprecedented judicial complexities had led, through proper process and time, to resolution that truly served the child at the center of the dispute. As Emma opened birthday presents with exclamations of delight, I observed Vanessa and Michael exchanging genuine smiles at their daughter's happiness. The journey from courthouse confrontation to birthday celebration had been arduous and unexpected, but had ultimately arrived at the destination family court always seeks: adults prioritizing a child's well-being over their own grievances. Have you ever experienced a dramatic family conflict that eventually found resolution? How did you navigate maintaining boundaries while still allowing for healing? Share your experiences in the comments below. Your story might help someone else going through a similar situation. If this story resonated with you, please hit that like button, subscribe to hear more stories about family transformation, and share with someone who might need encouragement that even the most difficult family situations can improve with time and effort. Thank you for listening to my journey from the receiving end of that courthouse slap to witnessing the healing that can happen when people choose to put children's needs first.